Board of Appeals of Tennessee is now in session.
Thank you, Mr. Hibner, and thank you, counsel, for agreeing to allow your arguments to be presented via video conference live streaming. And we're doing the live streaming so that we can fulfill our obligation to the public to have all of our proceedings available for public viewing and consideration. So thank you for that. Also, in a few days, the recording will be uploaded on the Administrative Office of the Court's web page, and it'll be available there as well. This is the 3 o'clock on Wednesday, June 3, 2020 afternoon docket. Let me remind counsel, if I understand it correctly, only one attorney is going to argue for the appellant and only one for the appellee. Is that correct? So no sharing of time. Very good. Then each of you get 15 minutes, and the appellant may reserve up to 5 of your 15 minutes for rebuttal. So when your case is called, please tell us how much. Mr. Hibner, please call the case.
Sun, Air, Water, and Land, Inc. versus Harold M. Jack Reynolds.
All right, you have the floor.
Good afternoon. May it please the court. I'm Keith Grant, and I represent H.M. Jack Reynolds. I may refer to him as Jack Reynolds instead of H.M. Reynolds, as most people do. I am reserving 5 minutes of rebuttal time, and it looks like the clerk has that already there. This case involves a promissory note that was initially signed in 1999, and it was for $200,000, but the plaintiff waited for almost 17 years until 2016 to file a suit on it, and at that point, with compounded interest, asserted that my client owed over $1.6 million. The promissory note at issue and the $200,000 loan was made at the same time as Dr. Dixon, who is the sole shareholder of Sun, Air, Water, and Land, Inc., also known as SAL, purchased property from Mr. Reynolds and from his wife in Sequatchie County, Tennessee. I think there are really 3 issues that kind of are overarching issues in this case. The first one would be Mr. Reynolds' desire to stay on the property. It's undisputed. The amount of work, the second issue is the amount of work that Mr. Reynolds put in both on the property and off the property that benefited Dr. Dixon, the sole shareholder of SAL. And lastly was the reliance of Dr. Dixon on Mr. Reynolds' work on and off the property. That was both to his benefit and to Mr. Reynolds' detriment. Now, this case is a convoluted one, and I've had several of those. This one, I think, tops those. It frankly doesn't fit into one neat legal rubric. There are no cases that I've found that are precisely on point, and laches seem to actually fit this case very well, and we've argued those in our brief. Not to go too much into it, but I think a summary of the facts is important. The parties' relationship began in the 90s, in the late 90s. Dr. Dixon, after negotiations, initially said that he would purchase the property underlying this case for $850,000. It was ultimately purchased for $650,000, and a promissory note was signed by Jack Reynolds, and he was loaned $200,000. All of that happened in the same, or around it in the same, this in our brief, was vague. Frankly, it looks like a form that was taken from somebody who is a lender, but SAL, to my knowledge, is not a commercial lender. But the vagueness on the interest, actually, the promissory note says, as to the interest to be charged after demand or maturity, and I'll quote, that interest rate so denominated and set by the lender from time to time as an interest rate basis for borrowing. Prime rate is one of several interest rate bases used by the lender. And I bring that up just to show, one is, even if there's no offset allowed, as we've
Excuse me,
sure
Mr.
that
Grant.
the note itself is actually clear enough.
Mr. Dixon, if you would mute your microphone, the camera keeps switching to you for some reason. Thank you, sir. Thank you. Please continue, Mr. Grant.
Thank you, Your Honor. So even if we're not entitled to an offset, I think there's an issue that the note itself really isn't clear enough for a total judgment or a total amount due to have been determined by the chancellor on this.
Pardon me, the original
however,
note, wait. The original note, as I read it, says payable at the rate of 10% per year.
well, it's 10% for that first 8 months, but then further down it says after demand or maturity, then it becomes it's that 150% of prime rate. And also, Your Honor, on that, and this is in I don't know the site to it, but this is in the record. You will see that actually the plaintiff compounded interest on that. And so the interest rates were 12.5, 13.5, even I think up to 14.5, and it was compounded. So even though the note doesn't say anything about that, that's how the interest was accrued during the pendency of the 17 years while the plaintiff waited to actually file a lawsuit to get money on this note.
So where was this issue raised below? I mean, there's not a whole argument, not a lot of argument in your brief about the proper calculation of interest here. I mean, you do say that the note is ambiguous in terms of how the prime rate is determined, but it looks like to me in the initial response to the motion for summary judgment, the only defense that was raised was breach of duty of good faith and fair dealing.
Yes, Your Honor, I think what initial response to summary judgment, and so I don't want to speak for the folks who were, but my understanding is that that issue for summary judgment was admitted, but for summary judgment purposes only. And so there's three things that you can do. You can admit, you can deny, or you can admit for summary judgment only. And they picked that third choice as to the amount ultimately determined to be due under the promissory note.
So for purpose of this argument, then we have to take that fact as accepted for summary judgment. So we really can't revisit that, can we?
Well, under the TWB Architects case, Your Honor, and that's 578 Southwest 3rd, 879. It's a 2019 Tennessee Supreme Court case. And in that one, kind of the same argument was brought up. And what the court said was, we find no merit to this argument. Braxton was required in its briefs to the record, and because they have done so, we accept that. And that was the same argument was made in that case, which was that the defendant in that case had not brought the argument up at the lower court. And so it is, and again, it's TWB Architects versus Braxton, and it's cited in my reply brief.
Well, and I'm familiar with that case. That's a case involving a novation of an architect's agreement. But I don't think there was any dispute that that issue was raised below. They raised a Rule 27 rule of appellate procedure argument saying there wasn't citation in their brief to where you could find it in the record below. In this case, the more problematic issue is it doesn't look like it was raised below at all, was it?
The issue was not raised below, Your Honor, and I'm actually looking in the TWB Architects case for that ending is actually the court was talking about that issue specifically. Here it is. TWB Architects argues, and this is, Your Honor, at page 889. TWB Architects argues that Braxton did not comply with Rule 5603 citations to the record in response to TWB Architects were not specific enough and thus improperly required the trial court to identify which facts were in dispute and which page in the record contained those facts. We disagree. So I think that with that, the issue is we can assert these facts even though they weren't asserted at the trial court level. And frankly, this issue, unlike the cases cited by the plaintiff, summary judgment granting is de novo with no credence given to the record below, and so, or to the decision below. And so with the de novo ruling and the language in TWB Architects, I think the court can look at this issue. There was clearly the evidence was there, Your Honor, although it wasn't specifically noted. The evidence was absolutely put into the record. Part of that was put in through the supplemental affidavit.
So Another point that you made is the answer that was a pro se answer was the filed here, but I couldn't
Yes, sir.
find an answer in the record anywhere. It's certainly not in the table of contents. And I don't see it in the supplemental record, but you cited to volume 2, page 29 for that, but I don't see anything there either. So where is this answer?
I think the answer is actually in the appellee's appendix. And I would have to look and see, Your Honor. If I cited to it, I would think that I would put the right side in there. Let me check and see. But the answer, and I don't know exactly, other than the fact that the court switched. It was in Sequatchie County. It was moved to Hamilton County. Answer is in, I think it was in the appellee's supplement, and it would be in their appendix at probably page 29 is what that was cited to. I'll look for that during the appellee's argument, and I'll come back to you for that. The other issue, I know.
Let me ask you before you go, because you only got a few minutes. A lot of the arguments you make, a lot of the issues you raise predate the signature of the novation. Doesn't that kind of moot out a whole lot of argument where you acknowledge somewhere that the debt?
Your Honor, I think, and I'm glad you brought that up. That's one of the more important issues. If you look at the novation, it says it was signed April of 08. There's plenty of documentation showing that in March of 09, Dr. Dixon is still asking Mr. Reynolds to sign this novation. And one of the more important documents is a March 13 document, and that's page 58 of our appendix, of the appellant's appendix. And in that one, the parties are negotiating prior to the signing of the novation. One of the things that is in the negotiation is a quid pro quo trade work for payoff of loan interest. And so one of our positions on that is, Your Honor, that the novation was signed because Mr. Reynolds was actually told that there would be a quid pro quo work payoff for loan interest. And that is part of the whole, both before novation and after, is that he should be entitled to the work that he has done for Dr. Dixon in the interim.
Did he put that in an affidavit? What is it that made that a genuine issue of fact for trial?
It was in the supplemental affidavit that I filed, Your Honor.
Okay.
And it's at page 56 of the appendix. And what that is that's an exhibit to the affidavit I filed as a supplemental response to the motion for summary judgment.
Okay.
With that, the two appendixes really include the pertinent issues, I think. I'm not sure why the record was convoluted. The affidavits in the technical record, the attachments to the affidavit were not.
All right, thank you, Mr. Grant. You'll have 5 minutes on rebuttal, and Mr. Dixon, please remember to unmute your audio, and we're glad to hear from you.
Unmute.
I'm sorry, we can't hear you, Mr. Dixon.
Can you hear me now, Your Honor?
Yes, sir. Good.
Okay, thank you. Sorry for that. Again, may it please the...
I lost him.
You've gone silent again.
Sorry. I just want to say this is my first argument before the Tennessee Court of Appeals, so I'm thankful and honored to be here.
Not to be too rough on you, at least I will. I don't know.
So I first want to address some of the facts that Mr. Grant addressed. He stated that the promissory note was signed in 1999 and the plaintiff waited 17 years to take any action. Of course, we've alluded to the fact that that's not true. There was a renewal of the promissory note in 2008 that went unmentioned, other than the last question from Your Honors. Also, the land transaction that precipitated, or I guess predated, I should say, the signing of this note is a bit of a red herring here. That's between Dr. Dixon and Mr. Reynolds' ex-wife. They had divorced in 1994. Now, addressing some of the arguments, Mr. Grant said there's not a real neat legal rubric for this case, and I beg to differ. I want to bring the court's attention to a case that was not cited. I actually found it this morning. And that case is Reynolds v. Allen. It's cited as 1993 Westlaw 38005. It's a Tennessee Court of Appeals case from the Middle District, and it involves none other than Mr. Reynolds, the defendant in this action. That case also involved a promissory note that Mr. Reynolds executed and which was later renewed. Also, similar to this case, Mr. Reynolds argued before this court that there had been various agreements, extraneous transactions that would serve to change what was due under that note and the renewal of the same. Now, 30 years later, he's made the same arguments to attempt to avoid payment on the note and renewal note in this case, those being that somehow his work over 20 years should count as payment, despite the unambiguous terms of the note and renewal note here, or that interest should somehow be forgiven. This court rejected Mr. Reynolds' arguments 30 years ago, and it should reject the same arguments today. And I want to quote one particularly pertinent section of that opinion. It states, "Modification of an existing contract cannot arise from an ambiguous course of dealing between the parties from which diverse inferences might reasonably be drawn as to whether the contract remained in its original form or was changed." And that is actually citing a further well-established Tennessee case, Baldaraci v. Ruth. That's a reported opinion cited as 256 Southwest 2D 390. Now, Mr. Reynolds' best case in this case is to create some kind of ambiguous course of dealing by bringing up any and all extraneous documents, communications, to try and establish that something should contradict the express written terms of the promissory note and renewal note. And I will mind you, Mr. Reynolds attested under oath to the authenticity of both of those documents. In his deposition, he confirmed that was his signature. There's been something brought up, I believe for the first time in the reply, about a date of the renewal note. That's the first we've heard of any challenge to that. And similarly, the letters that Mr. Grant has brought before the court, particularly this quid pro quo trade-off or payoff of loan interest. If your honors will review that document, you will see the only thing, it provides no reference to either the promissory note or the renewal note. It does say quid pro quo trade work for payoff of loan interest. However, it only says date of received by Harold Reynolds is March 13th, 2009. This respectfully does nothing to contradict the written terms of the agreement, and nonetheless, this was not raised appropriately below. I do want to address further the arguments that Mr. Grant did make in his briefing. First, for this set-off argument, he has set out the case of Helms v. Citizens Bank of Irwin, the 1936 case.
So
Respectfully,
are you conceding then the set-off argument was raised below?
no, I'm not, and I can get into that. Particularly what happened below, we filed a motion for summary judgment. The response was filed, and yes, in that response, they admitted to the amount owed. They admitted to the calculation of the interest, which was supported by an affidavit of the accountant of Saul. That was admitted for the purposes of the motion. Now, after we got to the hearing, Mr. Reynolds' only argument was that there was an alleged IRS 1099 in the amount of $250,000. The court permitted Mr. Reynolds additional time solely to produce the $250,000 1099. That 1099 was never produced. Instead, what happened was Mr. Grant made his appearance. He submitted this, motion to supplement his response, and that supplemental response was basically a document dump on the court. And at that point,
what type of 1099 were we talking about here? Was this forgiveness of debt income? What type of 1099?
I don't know because it doesn't exist.
Okay.
Apparently, he believes that there was a $250,000 1099 issued, and I would presume he means to forgive the debt. It just was never issued, and it's never been produced. And our accountant, who has managed the finances of plaintiff since its inception, has affirmed via affidavit that that just doesn't exist. It never happened. Does that answer your question, Your Honor?
Well, yeah, I believe so. Yeah.
Okay. So turning to just addressing the substance of the arguments that in fact have been made. Again, the Helms v. Citizens Bank case, even if the court were to entertain a set-off argument, which we contend is simply not appropriate here, it wasn't appropriately raised, that case involved two parties with a promissory note and certificates of deposit. Okay, this is not a case where you have one promissory note, one written instrument, and one party is disavowing that instrument and is producing no other written documentation. He's producing his own, allegations that he should have some right to a set-off that's not based on any actionable document.
What entity acquired the real estate here?
The real estate, again, the real estate was acquired by non-party George Dixon. George Dixon, he is the president of Sun, Air, Water, and Land, Inc. So realistically, when you're looking at the land transaction, which again I would submit is totally irrelevant for the court's consideration here, the land transaction was between Helen Reynolds, at that time was the ex-wife of Mr. Reynolds. They had no legal relationship. They lived together. They had been divorced for 5 years. Mrs. Reynolds sold the property to Mr. Dixon, Dr. Dixon, I should say. And separately, Mr. Reynolds and Dr. Dixon, through Sun, Air, Water, and Land, negotiated this promissory note. So we really have two non-parties on a land deal versus the two parties to this case, which are relevant to the promissory note.
What does this entity, Sun, Air, Water, and Land, do?
Well, right now, not a whole lot. What was happening back in 1999 was mainly an accumulation of land interests. And this particular piece of property at issue was about a 1,000-acre farm. Currently, they own well over that, but basically trying to acquire land and ultimately sell that land or make some kind of investment out of the land with preppers.
But you're saying the land in this case wasn't part of that portfolio?
Correct.
Because Dr. Dixon purchased it individually. Okay.
Correct.
What about my question about the answer here that was pro se answer that was filed? Where do I find that in the record?
Unfortunately, I believe Mr. Grant will agree with me, we've had some issues getting this record compiled. I thought we had basically designated the entire thing. It looks like certain pieces were omitted from transmission from the trial court. I believe Mr. Grant did include that in his initial appendix, but the entire record should have been transmitted. We've just had some trouble with that. I'm happy to resubmit that or do whatever is necessary to get that before your honors or answer any questions pertinent to that.
Well, I don't know that it's that important because we've got the response to the motion for summary judgment, so we know what defenses were raised, correct?
Yes, Your Honor.
And that's in the supplemental transcript or technical record, excuse me.
Yes, Your Honor. And I'll speak to those defenses since I only have, it looks like 5 minutes left.
Let me ask you this before you can do this on the way there. What is it that you say is the issue? Why do these matters that have been raised in Mr. Reynolds' affidavit, why do those not create a genuine issue of fact on his liability, if not on the note itself, at least some sort of mitigation of the interest or something like that?
Sure. And this all has to do with the express, unambiguous terms of both the note and the renewal note that have incorporated the same. The Tennessee law is well established that he cannot use inadmissible parole evidence to contradict the unambiguous terms of the writing. Now, Mr. Reynolds...
If it's a matter of performance or whether I paid or didn't pay, that's not contradicting the terms of it. That's deciding whether it's been performed or paid or not, or whether there was a trade-off.
I think I understand what you're saying. My response to that is that the note specifically required money payment to be used to discharge the debt. It did not permit performance of services, as Mr. Reynolds would now seek to contradict the terms of that note for it to include. Simply put at this point, just as the court held in Mr. Reynolds' previous action, he cannot modify this existing contract by simply bringing up this course of dealing. First, as Your Honor duly noted, was before he executed this note that said, or this renewal of the note that said, I'm extending the period another 10 years, and provided no recitation of any payment, nothing of that nature. It simply extended the statutory period for us to take action on the note, and that's exactly what we did. Furthermore, I do want to say, Mr. Reynolds, everything he has done or attested to doing was done for Dr. Dixon on this farm. The farm was purchased by Dr. Dixon individually. It was not involved in this entity. Okay, so separate parties can't, he's effectively saying his work for a non-party should offset his promissory note he executed for the plaintiff. And we would submit that that's, number one, it's not included in the promissory note. There's been nothing to suggest that, and it wasn't raised below.
Okay, thank you.
Just very briefly, since I only have a couple minutes left, I want to note the laches argument. Again, it wasn't raised below. It was wholly insufficient on its pleading, and overall, Mr. Reynolds has failed to address the substance of our argument in the brief through his reply. Namely, the statute of limitations applies to this case. The court properly held that, and there is only a potential case for gross laches if there's a statute of limitations applicable to a cause of action. And in that case, Mr. Reynolds would have to show some kind of prejudice, and it's usually a fairly high burden, something such as a destruction of evidence or the unavailability of witnesses. Nothing like that has been pled here. Effectively, there's just a circular argument that Mr. Reynolds has done all this work, and doing so for that length of time should somehow serve as prejudice. I would respectfully submit that there's no basis in the Tennessee law for that. I'm happy to answer any additional questions, but that's the argument I have. If there are no questions, I will concede back to Mr. Grant for his rebuttal.
Hearing no questions, we'll hear from Mr. Grant.
Unhook yourself, unmute yourself.
No matter how many times I do this, Your Honor, I still forget that. Let me first address this issue of the distinction between this promissory note and the property sale at issue in 1999. And again, turning to that May 29th, 2004 letter, and it's page 45 of the appendix that we filed. And again, Judge Jenkins, this is the attachment to the affidavit that we filed to supplement the response to summary judgment. This is a letter from Dr. Dixon, not from Saul, but from Dr. Dixon to Mr. Reynolds. On the second page, it says, in parentheses, after all, even though the big loan was a personal loan, in reality, it seems to me to have been a part of the farm sale. So those are words straight from Dr. Dixon saying that he agrees, or he thinks the $200,000 was in fact a part of the farm sale. In the correspondence that's in the supplemental affidavit, there's never a distinction between Saul as a party making the loan versus Dr. Dixon. Dr. Dixon, in fact, says that in page 57 of the appendix, he says, and that's the March 12, 2009 letter, Dr. Dixon to Mr. Reynolds says, you need to sign a novation to keep alive the loan we made almost 10 years ago. Not made with Saul, we made. And so during this whole time, Dr. Dixon is acting as if Saul is not an entity. And frankly, I think that it was Dr. Dixon's company. And so that's why he's acting like that. So the issue with these separate parties is simply not there. It's Dr. Dixon the whole time. Now they're trying to hide behind this veil of, well, it was Saul. The correspondence that's replete in the record that we filed in the affidavit we filed.
Why does it matter?
I'm sorry?
Why does it matter?
Because if the two, I think my understanding, Your Honor, from what Appley's argument is that Dr. Dixon's promises and his actions can't change the agreement of two separate parties. But the problem is these were not two separate parties. Dr. Dixon was, for all intents and purposes, Saul. And the reason that, if Your Honor, I think may have a question.
No. I still, to me, the question is whether the note was paid. Who the holder is a different matter.
The issue is, and the reason that matters, Your Honor, is over the course of the 17 years that no one took any action to collect. Now, they did ask for a novation. No action was to collect. During this time, they're compounding interest annually, even though the note doesn't say that. They're compounding interest annually. And during this time, Dr. Dixon continues to talk with Mr. Reynolds and tell him things like, I will waive the interest on the note. Thank you for the work you've done. We will, if you sign the novation, we will have a quid pro quo trade-off, interest for work. Those are things that are extremely relevant because the issue is Mr. Reynolds thinks, especially since Saul and Dr. Dixon sit on the rights for 17 years, Mr. Reynolds thinks that he's getting credit for these things that he's doing. And the record shows all of the things that Mr. Reynolds has done. He made him really almost $500,000 in property sales. He helped with $8 million worth of property sales. He performed numerous tasks both on and off the property, really for Dr. Dixon, because again, there was really no distinction made by Dr. Dixon between he and Saul. And so during the 17 years, Mr. Reynolds thinks that this is part of their agreement. Did they ever formalize that? Apparently they did not. But I don't think Dr. Dixon and Saul should be allowed to string Mr. Reynolds along, talk about thanks for all your work. I appreciate everything you've done. But
And then the other thing I would ask though, where was that raised in the record? In an answer, in an affidavit, or something to create an issue for trial on it?
Sure, Your Honor. Thank you. That is
Point to it. I don't need you to argue. Just point to it.
I'm trying to find it, Your Honor. I'm sorry, I am.
Okay.
It is in the reason I was looking at my notes. It's pointed to in our reply brief. It was addressed specifically in the summary judgment response, and I can read that to you.
Point to it now.
Sure.
Looking page.
Second, technical record number 2, page 183.
Thank you.
And in that's Mr. Reynolds' response to the statement of facts, Your Honor. And he talks about the plaintiff and Dr. Dixon entered into verbal agreements both before and after the execution of the initial note and the renewal note about life estate and about the repayment, about once the $2,000 repaid by the defendant to the plaintiff without interest upon the sale of the mineral rights. It's in that whole discussion where we talk about the credit that the offset Mr. Reynolds should be given is because of all this work that he's been doing on the
That
property.
references his the testimony that was given in his deposition.
I think it does reference some of the testimony in his deposition. Yeah, it does. Page 201, lines 2 through 25. Page 202 of his deposition, line 1 through 5. And Your Honor,
So that's number 5 then, okay.
yes. The easiest place in our reply brief, Your Honor, pages 6 through 8 is where that's addressed. And I feel like I've gotten loud, Your Honor. I didn't mean to be yelling at you. It's the Zoom thing makes it a little awkward.
Did just fine, Mr. Grant, and Mr. Dixon did as well. And we thank you both for your excellent arguments, and we'll take this matter under advisement. Mr.
Thank you, Your
Hippner.
Honor. Thank you.
Thank you, Your Honor.
This court is now adjourned.